Dear Lord, thank you for this day. Thank you that we can sit amongst ourselves and discuss what needs to be done for the nation and discuss what needs to be done. And thank you, Lord, for this week you've given us for council and other business that we need to attend to. And I pray for each council member, and thank you for all those that are here. And I pray for our nation. In Jesus' name, amen.
Call the roll.
Chuck Hoskin Jr.
Here.
Jody Fishinghoff. Here. China Gloria Jordan.
Present.
Lee Keener.
Ahomey.
Dick Lake.
Here.
Curtis Snell. David Thornton. David Walkingstick. And Frankie Hargis.
Here.
And you want to do?
Thanks, Sherry. We have a forum, and I'm told that the minutes from subcommittee meetings are ultimately approved at the committee stage, so we'll dispense with dealing with the minutes until we get to committee. We last left off going through a point-by-point review of Councilor Cowan Watts and Keener and England's draft Impeachment Act. Quite honestly, I had forgotten where we left off, although I do wonder if we've had enough time to review all of it offline, and if anyone, I had some amendments prepared, but what's the pleasure of the body in terms of how to proceed? Councilwoman Boyd?
Yeah, I make a motion that we dispense with going through the rest of the body of the act. I think everyone's had an opportunity to look at it. I'd like to hear the amendments and talk about those today.
And I think in terms of procedure, we may not need a motion, but this is an important act, so let's get the sense of the body about how we want to proceed. Councilwoman Gloria Jordan's preference is to proceed directly with amendments, and I think we have a second by Councilwoman Hargis. So let's have a vote on this. All in favor of proceeding in that fashion, say aye.
Aye.
All opposed?
No.
All right, we'll proceed in that fashion. And Councilman Keener, if we need to revisit any of these other definitions that aren't addressed on amendment, we may have a chance to do that in subcommittee. We certainly have a chance to do that in committee. We're going to spend some time studying this, but I do think that this will be a good way to get it moving on to the committee stage. So I'd entertain any amendments. Councilwoman Gloria Jordan, do you have one in mind since you were
I've asked Todd to write up some definitions so that we could consider 5 or 6 words within this Impeachment Act that may clear up a lot of problems for us down the road as to whether someone actually has, we would even consider whether someone has actually violated the Act. And I would like Todd to come forward and tell us what he's come up with as far as definitions.
And Mr. Hembry, what section are you going to direct our attention to?
The section will be, we'll deal with the definitions first, and that would be Section 4 of the Act, page 2. I want to recommend a series of additional definitions, I guess beginning with definition F, which would be right after E. In reviewing the minutes and in the tape of the last subcommittee meeting, there was a desire to look at the words that are in the Constitution and give some type of more specific meaning to them. Some of these terms are very subjective in their own right, so if we can be more specific about those, we need to be. The 2 sections of the Constitution that we were dealing with about the right to hold office is Article 11, removal from office of our Constitution. Also, Article 9 under election, there is a term that needs to be addressed or more clearly defined in legislation. As to removal from office, under Section 1, Article 11, it says the principal chief, deputy principal chief, members of the council, attorney general, and marshal shall be subject to removal from office for willful neglect of duty, corruption in office, habitual drunkenness, incompetency, or any conviction of a felony or a crime under the laws of the Cherokee Nation that, if committed in some other jurisdiction, would be a felony, or a misdemeanor involving moral turpitude or against the Cherokee Nation committed while in office. In reviewing the minutes, I was asked to come up with or explore definitions for corruption in office, habitual drunkenness, incompetency, and moral turpitude. Also, in reviewing Article 9, I've come up with a definition to define a position of or an office of honor, profit, or trust in any other tribe or nation of American Indians.
Do you have those where you?
Yes, let me read them, and then I'll give you my suggestions, and if the body approves, we'll put them in the definition sections, beginning with section. Did I say E or F? F. Section F. And again, a lot of these come up with or subjective terms in their own right. Moral turpitude. It's to quote a Supreme Court justice, it's said, well, define pornography. Well, I can't, but I know it when I see it. Is a statement. Just like moral turpitude, it's hard to define, but cases, courts and legal jurists have done their best to do that. The definition that I would recommend for moral turpitude is the act of baseness, vileness, or depravity in private or social duties which man owes to his fellow man. That's a lot of fancy words, but it's something more than just a crime. It's something that is devoid of basically humanity. It's vile. It's baseness, depraved. So those are. I would recommend that definition for moral turpitude, or we can just, if anyone's got any additional language, we can look at it.
Todd, is that definition drawn from other definitions of moral turpitude that you've found?
There are a number of cases. You type in moral turpitude in Westlaw, you're going to get a ton of cases. So you're going to, and I've looked at those, and just about every one of them comes up with that same theme. Okay, Black's Law Dictionary, which I have right here. That's they all. You'll get 100 cases that say the same thing: baseness, vileness, depravity, in one way or the other. Duty that you owe to your fellow man. So that's the research that I found on those.
I think ultimately these definitions are kind of elusive, but it is, I think, good to have something that's grounded in some area of the law in this act, because otherwise we give no guidance at all to the arbiter of this act. So do I hear a motion to amend to include that definition?
Are we going to do them individually?
We could wait and hear Mr. Hembry's full presentation. That's on definitions. That's fine. But
okay.
Would it be possible for us to get a copy of them before we make a final vote on them too?
Sure. Yeah, we can make copies of these.
Okay.
How do you want to make copies right now?
I want to hear the rest of them too. So.
Well, let me just go forward with the rest of the definitions, and then we can entertain the actions of the subcommittee. The next one is, or the first one listed in the Constitution is willful neglect of duty. Now, there is no, that was not one that in a minute said to be defined, and I don't know if you would want to put in a definition of neglect. I mean, that's pretty self-explanatory, that, that you willfully, which means with purpose, neglect to do the duties by which these officers have been sworn. So as to willful neglect of duty, I don't believe that there's really a need to put in a specific definition of that, but we can work on it. Corruption in office. I do have a definition for corruption in office. Black's Law Dictionary defines it, and I would agree, is that the act of an official or fiduciary person, that means someone who has a duty, who unlawfully and wrongfully uses his or her station or character to procure some benefit for himself or for another person, contrary to the duties and the rights of others. You have a duty, and you have a fiduciary duty, and you're using that to gain to gain for yourself or for someone else. I think that's a good broad definition of corruption in office. The next one that I was asked was habitual drunkenness. I'll tell you that during the Constitutional Convention, I fought to keep this out of our definitions. I think number one, it's arcane, habitual drunkenness, I just didn't like it being in a tribal constitution, to be honest with you. But it is here, so we need to define it. Habitual drunkenness, one who frequently and repeatedly becomes intoxicated by excessive indulgence in intoxicating liquor, so as to acquire a fixed habit and involuntary tendency to become intoxicated as often as the temptation is presented, even though he remains sober for days or even weeks at a time. That is your classic habitual drunkenness. Again, I wish it wasn't in our Constitution, but it is. But I think that is.
Can you read that one more time?
Yes. It is the most entertaining definition. One who frequently and repeatedly becomes intoxicated by excessive indulgence in intoxicating liquor, so as to acquire a fixed habit and an involuntary tendency to become intoxicated as often as the temptation is presented, even though she remains sober for days or even weeks at a time. Go out, have a party, you get drunk. That's not habitual drunkenness. It is a sustained activity over a period of time that you do. So, basically, it's like alcoholism. That is what it is, and alcoholism is a disease, and I think that's another reason why it shouldn't be in our Constitution, but yet it is. But the next one, incompetency. I would rather be, and that one's extremely subjective, and I would tend to be broad on this, this definition. Incompetency, lack of ability, legal qualifications, or fitness to discharge a required duty. You're just unfit. You lack the ability to carry out your duty or your charge, and that's just the best way I can put it. And then we've talked about moral turpitude, which is a common theme basis, the baseness and vileness, or the depravity in private or social duties which man owes to his fellow man. So those are pretty stock definitions. It will give the tribal council, if someday they are in an impeachment court, some type of definitions to go by. And I think that it will help out the trier of fact down the road. Now, there's one definition under Article 9, elections. Okay, now let me read you the section. This is whether you have eligible to hold office. Article 9, Section 2. No person who shall have been convicted of a felony charge under the law of the United States or any state, territory, or possession thereof, or a crime under the laws of the Cherokee Nation that if committed in some other jurisdiction would have been a felony, shall be eligible to hold office or appointment of honor, profit, or trust within this nation, unless such a person has received a pardon from the appropriate jurisdiction. I don't think it's necessary to define felony or misdemeanor. They are charges in a state court, and you will have to be convicted. Either you are convicted, a convicted felon, or you're not. So that would take care would remedy itself. Now, the one term, and the term that I think needs to be interpreted and defined is what is an office of honor, profit, or trust. And that person interpreting those words could be extremely far-reaching, or they can be. So I think it's necessary for us to really get a grasp of it. Now, I think it's important that when we're discussing this definition, it is under the article of elections. Okay, so these are to consider elective positions. So I think we need to call it what it is. I would recommend an office of honor, profit, or trust. For the purposes of this act, such office shall mean an elected position or a position appointed by a tribe's highest governing body. Such an office does not include employment, contract services, or consulting agreements. Because, again, we are talking about elections here. We're in the section of elections, so that's the umbrella that you're looking at. If you go to the Choctaws and run for council, well, and you're elected, well, that's clearly an elected position. That is a position of honor, profit, or trust. You would have to get permission by this council in order to hold that position. A position appointed by the tribe's highest governing body, that is normally the tribal council or general council, depending on the tribe. And that means you're availing yourself to confirmation or appointment by that highest governing body. And so, therefore, if you're going to avail yourself to do that, if you need to get permission of this council before that happens. Now, there are going to be instances in the most, the interesting word in that whole string of sentences is profit. What's the position of profit? I mean, it can be anything. That's why I want to make sure that we specifically exclude employment agreements. As I said, it does not include employment, contract services, or consulting agreements. That's my recommendation on those, and
I make a move to accept all his definitions.
We have a motion to accept the amendments to the draft legislation under Section 4 definitions. Do I hear a second? Second by Councilwoman Hargis. All those in favor?
Aye.
Opposed? Thank you, Todd.
So that would conclude the definitions part. I've reviewed the additional language. I'll just turn it over to the chair. It's your language. So.
Well, Well, thank you, Todd. And I guess I would ask you from the outset, Todd, the document you're referring to, the document that I had distributed last subcommittee meeting and I've had redistributed today, it has a blue line version for the changes that I've made. I want to go over those, but Todd, did anything jump out at you as a concern with any of the language that I had suggested?
There was one area that I didn't that I needed some clarification on.
Maybe as I go through
Okay.
it, we can jump on that. From the outset, what I had in mind as I drafted this language is that impeachment is only one, and perhaps the most extreme way to hold an elected official accountable. We already have the ability to go to the Attorney General and say, that councilman is violating the law. In fact, we kind of have a duty to do that, or that the chief is violating the law. There's already law enforcement in place to enforce the laws and determine whether an elected official has broke the law. The only question here is, how should we structure our impeachment statute? I think given that we have removal capabilities in our Constitution, that is to say the people can remove elected officials, given that we already have a way for the Attorney General and the Marshal Service to investigate and prosecute, we really need to reserve impeachment for really the most egregious offenses, and it needs to be very rare in sort of the grand scheme of things that we use impeachment. We ought to use it reluctantly. So that's what I had in mind as I made some amendments to the draft act. First of all, let me direct your attention to page 3 of this blue line version under section B, initiation of impeachment. It wasn't entirely clear to me how one gets the ball rolling when you try to impeach someone. It does seem to me that it needs to be a formal process from the get-go. It doesn't need to be a comment to somebody that so-and-so did something, needs to be impeached. It needs to be very formal from the get-go. So at paragraph B3, we have filing of impeachment allegations. Under this amendment, the only way you can initiate impeachment is if you file an allegation with the Speaker of the Council, send a copy to the official who's accused of the impeachable offense, you recite the basic allegation, and you sign it under penalty of perjury. If a person feels strong enough that somebody ought to be impeached, then from that earliest stage, even if there's not been a full investigation, if you at least have a genuine belief that someone's committed an offense, and you're not knowingly, willfully lying about the impeachment allegation, then you ought to be able to sign your name on the line. And so that allegation would then be assigned by the Speaker of the Council to the Rules Committee or to such subcommittee that the Rules Committee shall deem warranted. So that's really the first thing, is to set a strong, fairly high threshold to even initiate this process. Todd, did that cause you any concerns that we structure the process that way?
No, I think that's a very good point, and I would agree that things may be said in the heat of the moment or the heat of the meeting. Well, that person just needs to be impeached. And I think there should be a strong structure, triggering mechanism, and yeah, you got to put it down in writing. You need to be specific, and you need to mean what you say.
I'd kind of like to move on because some of these are sort of, they sort of relate to each other, so I'd like to kind of give a full discussion of these amendments. But does anyone have any questions or comments about that first paragraph, this idea that we ought to file formal articles or allegations of impeachment, rather? Okay, seeing none. Under Section B, there is a means for the chief to recommend impeachment. Keep in mind that impeachment is uniquely the domain of the council. It's not something the chief can do unilaterally. But certainly under the Act, the chief could recommend that impeachment proceedings start. And under this, it borrows from the existing language. If the principal chief hears about allegations of an impeachable offense, again, that allegations are filed, by any official, and we've defined official in this act. He can appoint a special prosecutor. That special prosecutor could recommend action by the council, that action by the council take place. So in other words, an allegation is filed, the chief could appoint a special prosecutor, and then the special prosecutor could recommend action by the council. It doesn't mean the council has to take action. It just means after those first two steps are taken, the council could take action. The council could decide that it's not sufficient to proceed, or the council could decide that it's sufficient to proceed. And the other way to initiate it is under Section B1, where the council, upon, again, getting that allegation of an impeachable offense, that written under oath allegation, the council could, by 2/3 of the body, appoint a special prosecutor. And that's a key change from how it was drafted. As it was drafted, action could take place by a simple majority. I think, given that we have the powers of removal, given that we already have a law enforcement structure in place to investigate election officials, that it really ought to meet a high threshold before we expend. Because keep in mind, impeachment is not only a very serious proposition, it's going to drain serious resources from this body. It ought to only happen if there is such a serious allegations that 2/3 of us say we've got to take action. So that's why I raised that threshold under Section B1. Does anyone have any questions or comments about those? Okay. Section B4 talks about the facts that council controls the impeachment proceedings at all times. And the significant part here is that at all times, if we decide that we need to suspend the impeachment proceedings, we may be into it. We may have already had a special prosecutor recommend X, Y, and Z action take place, but at any time, we could stop the proceedings, and we could do it for any reason. And it could be because the official decides that they're going to resign, or that some other disposition is warranted, such as censure. So in other words, we might get through the process and think, this is an impeachment allegation, it's very serious, but it doesn't warrant an extreme punishment of removal from office, so we're going to censure the person, we're going to suspend proceedings. I think this is necessary because we don't want impeachment to have a life of its own. We don't want to start it and then not have the ability to stop it. Because again, impeachment is a very serious proposition that we ought to always maintain control of. I'm going to just work backwards a bit. Grounds for impeachment under Section 5A. If we've already defined some of the grounds in there. It says officials shall be liable and subject to impeachment for, and then it has the various things you can do to get impeached. One is willful neglect of duty, and I agree with Todd that it really is very elusive to try to define willful neglect of duty, but I do want to attach one partial definition to it. I think that if an official makes a frivolous allegation of an impeachable offense, that is so serious, that in and of itself is willful neglect of duty. If you are going to make a false allegation against another elected official or an appointed official as provided in this draft act, if you're going to abuse the process in such an extreme way to cause this council to expend great resources, to cause great public embarrassment to another official for no good reason, that in and of itself should be grounds for another impeachment proceedings. Again, doesn't mean it's going to happen. It just means that it can happen. And Todd, does that give you any reason to pause?
No. The one thing that impeachment needs to guard against is what you described there, the dueling impeachment articles. I can come up and say and initiate an impeachment action. Well, there's your headlines: impeachment action initiated. It may be totally false. I may accuse you of habitual drunkenness. Okay, and I might be the only counselor that will vote in favor of those articles, or maybe or a very small majority. So I do think that there needs to be a mechanism that looks to limit the abuse. And it all comes down to, folks, that these are very serious matters. As we have said several times today, is that impeachment is not to be taken lightly, and it should not ever be used, to gain political points. If you believe that someone is, truly incompetent or corrupt, well, those are serious deals. But it's not just to be, used in what we have come to know as the silly season. So I think some language like that is appropriate.
And we may work on this if it passes here. We may work on it more here, but we could work on it more in committee. But one thing is the idea of what is frivolous is also very difficult to define.
It's my side here.
Okay, very good. Defining frivolous is going to be an exercise in futility. Ultimately, that's going to be in the eye of the beholder. What this definition says is that if you make an allegation of an impeachable offense, and it doesn't sustain at least a simple majority, which would fail, but it doesn't even get a simple majority, that is essentially a presumption that it was frivolous. It's a rebuttable presumption, but it's a presumption that it's frivolous. We really have to guard against abuse of this process, given that we have all the other means available to us to keep elected officials in check. So that's the thinking behind that. I'd like to direct your attention now to page 5 of my draft under section, it's paragraph K of section, whatever it is, but paragraph K. Let me revisit. Todd, I was just saying my opinion is that trying to define frivolous is also an exercise in futility, and ultimately it's going to be up to the arbiter to decide whether it's frivolous or not. There's plenty of definitions out there that help us understand that, but I think that if it doesn't sustain at least a simple majority, that creates a rebuttable presumption that it was frivolous. Doesn't mean it's going to ultimately be an impeachable offense, but you better have your ducks in a row before you accuse somebody of an impeachable offense. And Todd, I was moving ahead to paragraph K, found on page 5. If you make a frivolous allegation against somebody, and then you are yourself convicted of impeachment for having made that frivolous allegation, I think you ought to be liable for up to 3 times the cost of the attorney fees of the person you accused. Again, I feel so strongly that impeachment ought not to happen unless there is a very well-grounded reason that we should completely, essentially suspend the democratic process. Keep in mind, most of the folks that are under this act are elected officials, that we should upset an election, expend all the resources in removing a person from office. It better be a serious proposition, because it should be. And if it's not, and then you yourself are impeached for engaging in frivolous conduct, you ought to have to pay, because it's going to be very expensive for someone to defend themselves under this act. Councilman Jordan.
I make a motion that we approve all the amendments that have been proposed by the chair.
Okay. And we now go into discussion. Well, we have a motion and a second. Any discussion?
This will be, Mr. Chair, this will be just to be approval of the amendments and not the balance. Is that right?
This will be the improvement of all the amendments that are set forth in my document and in Todd's document as well. We'll roll those all into a single action.
Okay.
And then just to jump ahead, I think we ultimately give some recommendation to the committee whether to pass or don't pass. But are all minds clear that this is to amend based on the document I passed out and the definitions that Mr. Hembry provided earlier? Okay. All right. All those in favor of amending, say aye.
Aye.
All opposed? Very good. Councilman Jordan.
I now make a motion that we take the Act revising Title 51 that was proposed originally by Councilors Karen Watts, Lee Keener, and Buell Anglin, with the amendments that have been approved by this body. That would be all of the amendments in blue that are on the Act before us, along with the definitions that have been previously voted on and proposed through our legal counsel, Todd Hembry, I make a motion that all those be rolled into one act, and that those be forwarded on to Rules Committee for January 26th from this body as a recommendation that those be approved.
Second. We have a second by Councilman Keener. I have a question for you, Todd. Does this, in terms of formalities, does this go with some recommendation to pass, or how does this work in terms of proceeding?
I would take a vote on, with the recommendation do pass, if that's the will of the body.
Yeah, I think that's how I understood the Councilwoman's amendment in the second. Is all minds clear that we're recommending to pass on the 26th? Would that require an amendment of the agenda, but we would be recommending that the agenda be amended?
And just to make sure all minds are clear, we've approved all the, I think you called them definitions, that are proposed by Mr. Hembry. We've approved all the writing in blue, and we've kept the underlined items proposed originally by the authors. Is that correct?
That's correct.
And we're now proposing as a body, a subcommittee, that we approve those and send those on back to Rules on the 26th of January. Okay.
Councilman Keener.
Just a point of information, on the definitions, under definitions section 4, I made those 5 new definitions, F through J. Is that correct? Or because we weren't going to roll those up into one?
I actually have a K.
Do you? Okay, I have let's see, moral turpitude, willful neglect of duty, corruption in office, habitual drunkenness, and incompetency.
And then there was, what was that last one, Todd, where you were defining?
Office of Honor, Profit of Trust.
Yeah, that was
Okay.
K, wasn't it?
Yeah.
Okay.
Okay.
Thank you.
All right. All minds clear. Okay. All those in favor, signify by saying aye.
Aye.
Opposed, same sign.
Just as a matter of housekeeping, Mr. Chair, would we now have Todd take this and add, I guess, blue line definitions? And,
Yes.
And then could we, just for purposes so we know where everybody's at, Lee, would you want him to put your underline in blue too? So when we send the document to Rules, then all the blue is what we're recommending. Does that make sense?
Or red?
Or however, just so we can see, because I'm having a hard time keeping up with what our, okay. Blue or red, whatever your preference is. Change it all to red, I guess, wouldn't it? It'd probably be better.
Well, I was thinking,
He wants
Mr.
his.
Chair, I was
Oh,
thinking,
okay, thinking yours in red and everybody, all come from the committee in blue?
if that's the will of the body.
Okay.
That's fine.
Mhm.
Okay. Okay. All right. Are there any announcements?
I just want to say I'm proud that we got this done in a timely manner. I would like, as part of this committee, I would like to add my name to this as a sponsor, if that would be possible.
I think that's good. Does anyone else want to join as sponsor? Okay. Looks like the whole
This
subcommittee.
good committee work. We should be proud of it.
Okay. If there's no other announcements, and there's also no need, I think, to schedule another meeting, we're optimistic that we'll get through committee.
Will the chair try to see that that gets on the proper committee that it has to go back into?
I think we're past our deadline, but we'll certainly amend on the floor, and I would assume the whole subcommittee supports that. Okay.
Thank you.
All right. No other business. We'll be adjourned.
Glad we got it done.